4-1 decision in favor of Trump. The two in the majority, one was Judge Justin Walker. He wrote the history-rich opinion I'll be sharing with you. I will link the entire document, by the way, it's in the description, so you can read the whole thing. We'll only have a portion to read the interesting part this morning. But Judge Walker, who wrote this history-rich decision in favor of Trump, he was appointed by Trump to the federal bench in 2019 in the Western District of Kentucky, and then he was elevated by Trump just a year later in 2020 to the District Court of Appeals. Joining him, in his opinion, was Judge Karen Henderson, who was appointed to be a federal judge originally by Reagan and then elevated to the District Court of Appeals by George H.W. Bush. And the dissenting opinion here, which we won't have time to get to today, but you can read in the opinion, in the description, was Judge Patricia Millett, who, of course, was appointed by Barack Obama. No surprises there. Do we really have a judicial system when you can predict the outcomes purely based on who appointed these judges? Or has the Article 3 judicial branch simply become just another political branch of government, which it absolutely is not supposed to be? So this is Judge Walker, who was appointed by Trump in 2019 to the federal bench and then appointed by Trump a year later to the District of Columbia Court of Appeals. Article 3 of the Constitution vests the executive power in a president of the United States, singular, and requires him to take care that the laws be faithfully executed. To protect individual liberty, the framers created a president independent from the legislative branch. To further safeguard liberty, the framers insisted upon accountability for the exercise of executive power, so they lodged full responsibility for the executive power in a president of the United States, who is elected by and accountable to the people. This is all part of the separation of powers created by our founders, not common to other governments. In the parliamentary system, the legislative and executive functions are merged. America did not want that. We saw how the parliament worked in England, who, by the way, we shot in the butt to get out of our country. Continuing, executive branch agencies do not disrupt that design of the founders when they are accountable to the president. In other words, accountable means he can fire them. But consent of the government is a sham if an administrative agency, by design, does not meaningfully answer for its policies to either of the elected branches. I just referred to this. Who's their boss? How do we hold them politically accountable? Nobody. That's why the Supreme Court has said that Congress cannot restrict the president's removal authority over agencies that wield substantial executive power. That Supreme Court's precedents control this court's case, the Court of Appeals.